You're a police officer, not an attorney. You didn't go to law school. You went to the police academy. And at the academy, I'm guessing they didn't do a very good job of teaching you what the law was about search warrants. Now, you have to draft search warrants and you have to go to court and testify, and you're expected to know all the law about them, but you haven't really been taught. In this video, I'm going to break down the basic anatomy of a search warrant and give you a few tips on how to write a search warrant. Coming up. Hey there everybody, my name's Eric Scramlin. I'm an attorney and former prosecutor, and now I'm the owner of Tactical Legal Solutions LLC, where I train police officers to think like a lawyer. Before I get started with the video, if I could ask you to take a minute and hit that subscribe button down there. On this channel, I break down training topics and case law to help you, the law enforcement community, stay up on the law. You can head it over to my website at tacticalattorney.com if you want some more information about the courses I offer. As a matter of fact, I just put together my basic search warrant course where I will come to your department or meet with you virtually and teach you how to draft a search warrant. Let's dive right in and start from the beginning. To understand search warrants, you have to understand the Fourth Amendment. The Fourth Amendment prohibits unreasonable searches and seizures. And our courts have read the Fourth Amendment to say basically that the courts have a strong preference for warrants. And let me give you an example of why you always want to do a warrant if you can. If you draft a search warrant and search a car or a backpack or whatever the case may be, then it is up to the defense to go into court and challenge the search warrant. It's presumed to be reasonable because there's a signed warrant by a judge. Now flip that. If you search a bag based on, exception to the warrant requirement, like a Terry frisk, or you search a car under the Carroll Doctrine, or some other exception to the warrant requirement, then the burden is on you and the prosecutor to go to court and explain to the judge why it was reasonable to do what you did rather than to get a warrant. So it's always best to get a warrant when you can, because our courts have read the Fourth Amendment to mean that there's a very strong preference for warrants. I'm going to break down a search warrant into its individual pieces, and I'm going to recommend that you guys, when drafting a search warrant, break it down into pieces. Before I get to that, give you a big picture analysis. Search warrants require that in your affidavit for probable cause that you give the judge, the magistrate, the judge that's going to sign the search warrant, enough information to establish probable cause. The courts have told us that this is a common sense standard. You don't have to be 100% sure that there's going to be incriminating evidence in the place to be searched. In fact, you don't even have to be more right than wrong. You just have to establish probable cause, or otherwise put, you have to establish that there's a probability of incriminating evidence in the place or thing to be searched. To put it very simply, you're going to need to provide the judge who's going to sign the warrant with enough information to conclude that the items sought to be seized are evidence of a crime and that the criminal evidence sought is located at the place to be searched. With that said, it's very important that you understand how a search warrant works. If you know how it works, then you shouldn't make some of those common mistakes that I saw all the time as a prosecutor. Let's take a look at a search warrant as a whole, and then let's break it down into those individual pieces, because what you're going to want to do is create a template where you have the basic parts of the search warrant. You can go in, fill in each of the subcomponents, put it together, and then take it to the judge for a signature. That usually breaks down into 3 attachments. First, we start with attachment A, which particularly describes the place or the thing to be searched. In attachment B, you're going to particularly describe each item of evidence sought to be seized. And finally, in attachment C, which is really going to be the meat of your search warrant, you're going to attach the information to establish a basis for believing the items you're looking for are evidence of a crime. You're going to break that down into 2 parts, essentially. You're going to list your information, or what we call the affiant's information, sort of like a resume, your background, your training, your experience, and then you're going to list the probable cause statement. Let's start with attachment A. The law says that you must particularly describe the place, thing, or person to be searched. What that means is, as the court has also stated, that any officer that's not even connected to the case should be able to read your description here in attachment A and be able to figure out what house it is. what vehicle it is or given a sufficient description of a person. So for example, if you're going to do a search warrant on a house, you're going to want to list the address, but you're going to want to be more specific than that. Describe the house. What color is it? Does it have shingles on the roof? Does it have a metal roof? What color is the roof? Is there a chimney? Give sufficient facts to really explain that house. A lot of times you may find yourself in a situation where you have multiple houses that look the same or even multiple houses on one lot. It's okay to take a picture of the house, do your description, and then attach that picture as a further description of the house. If it's a vehicle, you'll want to do the same thing. You're going to want to describe the vehicle. What's the make? What's the model? What color is it? Do you have the VIN number? Is there a registration? Is there a license plate? Put as much particular information in there as you think is necessary to describe that vehicle. Next, in attachment B, you're going to particularly describe the evidence you're looking for. This is where I start to see problems when I've reviewed search warrants, is we're too general here because the law has clearly stated that general exploratory searches are forbidden by the law. That means you got to be very particular in how you list your evidence. You're going to want to avoid those general statements like evidence of criminal activity. Instead, be specific. If you're looking for stolen property and the stolen property, is a 50-inch TV, then you're going to want to list particularly a 50-inch TV, describe it, use the serial number if you can, and then we're going to go into a little bit more detail next about evidence that might be tied with the criminal activity associated with stealing that. I also want to mention that the type of crime is going to be important here when we list what kind of evidence we're looking for. For example, if you have a white-collar crime where you have like a business that's embezzling money or something like that, you're not going to list, page 5 of the 2017 tax records because you don't know where the incriminating evidence might be. So you can be a little more general, such as list tax documents or QuickBook accounts or business ledgers in general, because you don't really know, the incriminating nature is not immediately jumping out at you. So in that circumstance, it's okay to be a little more general. Now, if you're doing investigation in drugs, then you're going to want to be a little more specific as to controlled substances. Again, let's go back to our example of using a vehicle. So you've listed the vehicle and described it in attachment A. In attachment B, you're going to list the evidence, particularly what you're looking for. So if you have a 55-inch TV that you're looking for, you would list in attachment B, 55-inch TV. You put the serial number if you knew it, a description, the brand, the make of the TV. But not only that, you can also list things that might be connected to that. So if you know the television was stolen through a burglary, you could also list burglary tools, crowbars, picks, bolt cutters. The type of evidence that would be associated with that particular type of crime, you're going to want to list that as well. In attachment A, you particularly described the place or the thing that you're going to search. In attachment B, you've described the particular evidence you're looking for. Now it's time to move on to attachment C, where you're going to establish the basis, the probable cause, the nexus. But as I mentioned, the first thing you're going to need to do is give your information, the affiant, that's you. Here's where you're going to want to list your training, your experience, the fact that you're certified, salaried, commissioned officer, and anything that might be relevant to what's going to come next, the probable cause statement. The probable cause statement is where you are going to explain to the judge the basis, the connection of why those things you listed in attachment B are actually evidence of a crime. So here's where you're going to have to list the basis and give probable cause. How are you going to do that? You're going to use what I call the 3-step method, where you're going to answer 3 questions. If you can answer these 3 questions, then you can likely establish the probable cause that's necessary to meet the requirements. Number 1, how did the investigation begin? Let's go back to our car example. This is where you will want to tell the judge how you came into contact with the vehicle, explaining why that vehicle in attachment A has the evidence that you listed in attachment B. So for example, if you were on patrol and you saw this vehicle speeding at like 15 miles per hour over, made a lawful traffic stop, approached the vehicle, arrested the driver on a suspended license. During an inventory, you saw evidence of stolen property like bolt cutters and what appeared to be a TV with a partial serial number match. That is how your investigation began. You'll want to list that, and you'll want to give the judge enough detail about that investigation to make the connection. Question number 2. What is the nature of the crime? It's very important to list what the nature of this crime is, because that's going to determine what the connection is, what the evidence you're looking for. So, for example, if we're looking for stolen property, that is a stolen property theft case. Is it a controlled substance or drug case? Is it a white-collar case? You need to be specific on what the type of crime is, because that's going to tell the judge what the connection is with the evidence you're looking for. Again, for example, you're talking about a stolen property case in our car. So you're going to want to tell the judge about the theft. Give the background information that the bolt cutters and the burglary tools is going to be evidence of this crime, because of the type of crime that we're dealing with is the type where someone broke into a house, stole the TV, and these burglary tools are going to be evidence in the case. And finally, question number 3, how was the crime committed? Again, if we go back to our example with the vehicle, if you can explain that the crime was committed based on someone breaking into the house, they used tools to gain entry to the house and then stole the TV, that's important to know because it shows the connection to what you're looking for. A different example, maybe it's like an armed robbery. If you can explain to the judge your investigation, the nature of the crime, a ski mask might have been involved, or a particular type of clothing that will tie into eyewitness testimony. You can see what you're doing here. You're showing the judge a connection based on whatever you listed in attachment B. You're showing how that's connected to this crime. You've got to list that information so the judge can find probable cause. That's it. Those are the 3 questions. If you can answer those 3 questions, you should be able to establish enough information for the judge to find probable cause. Once you've drafted your attachments and your search warrant is, in your mind, ready for the judge to sign, take a step back and find an experienced officer who's written a few search warrants and have them proofread that thing for you. And if you're lucky enough, if you have a prosecutor or district attorney in your jurisdiction that reviews search warrants, I did that for many years. I had officers coming over at all hours of the night, calling me at 2 in the morning, emailing me in the search warrants, and I would spend a lot of time going over and making sure it was correct, because it's very important. You're likely going to find important evidence that's going to be used in the prosecution. Your DA, your prosecutor is going to want to make sure that that search warrant was done right. And don't forget, you're invading on someone's reasonable expectation of privacy. This is a big deal for the courts, and judges are going to really make sure that it's done correctly when we're invading on someone's privacy rights. So take time, proofread that thing, get a DA to approve it before you take it to the judge to get it signed. All right, guys, I hope that helps give you a little bit better understanding of the anatomy of a search warrant, how it works, and a technique that you can use to put your search warrant together. Hey, if you're still struggling with search warrants or you need a refresher, don't forget you can go to my website at tacticalattorney.com. I have full search warrant courses available. I will come to your department or do a virtual training with you, and I will teach you how to write a search warrant. Basic all the way through advanced level search warrant. So I hope that helps, guys. Make sure you hit that subscribe button. Until next time, stay safe out there. And remember, every battle is won before it's fought.